my name is Charlie Earn, and this is my land law presentation on giving legal advice for the lease issue faced by Roland. In this presentation, I will be conducting it as if I am directly providing advice to Roland. So, to recap the brief facts of the issue, Mr. Roland, you entered into a lease agreement with Ricky, in which the terms were 1. The rent is to be paid 1 year in advance before the start of the lease, and 2. The lease is for Ricky's business premises. This lease is written and signed by both parties, but it was never formalized. 2 weeks before the start of the lease, Ricky fell ill and faced financial problems after paying off his medical bills. So you accepted his part payment of 5 months of rent. However, things turned sour when after 5 months, you informed Ricky that he still has 7 months rent arrears, and you wanted him to honor the agreement, which he refused to and continued to stay on the property. Now, from this we can see that your main concern is this. You want Ricky to either honor the agreement and pay the rent or leave the property. However, you have concerns on this because Ricky has stated that he is not bound by the agreement, which is not formalized. So to break it down, I will first explain to you about your concerns regarding the lease and whether or not it can be enforced against Ricky. Then I will also explain to you the kind of actions that you can take and the kind of challenges that you may face. So, what is a lease? A lease is an estate in land where there is an arrangement for the landlord to grant the tenant rights in the land they lease, where the tenant enjoys exclusive possession, which can be simply defined as control of the land, for a specified term, usually at rent paid to the landlord. Normally, a leasehold will provide the parties proprietary rights within the same piece of land, and therefore they have to make promises, also known as covenants, to ensure that each party does or does not do certain things in relation to the land. A lease usually, as in your case, begins with a contract where the parties list down the terms and promises to be followed. In most cases, even if there is no initial agreement to lease and is straightaway executed by deed, there will still be terms of the lease that need to be followed. Therefore, it can be said that the basis of a lease is a contract, and all the contractual obligations of a lease need to be followed by the landlord and tenant who originally entered into the lease agreement. Meanwhile, formalities are procedures in law which need to be abided for the law to recognize proprietary rights, which can be understood as rights in land which will be able to affect anybody who interacts with said land. Because of how powerful proprietary rights are, the law will require people to go through set procedures in order for it to be legal, and therefore protected by law. However, the courts will still exercise their power and inherent jurisdiction and protect rights which are not legal, which means that they never went through any formalities, to ensure that there is fairness in the process, hence the rights are equitable. When you apply this logic to leases, that is the effect of formalities on leases. From the diagram, you can see that the law sets the threshold for the required formalities of leases. If a term of a lease is more than 3 years, pursuant to Section 52, subsection 1 of the Governing Statute, Law of Property Act 1925, the lease must be created by a deed, which is a formal document with strict procedural requirements. Moreover, if the term of the lease exceeds 7 years, depending on whether the land is registered or unregistered, different registration requirements also apply. However, the exception for the formality requirement is if the lease is for a term of less than 3 years. Then, the lease will only need to be made in simple oral or written agreement, and the tenant is already in possession of the land at a market value rent. It is also possible for the lease to be a periodic tenancy with a period not exceeding 3 years, in which the lease will only exist for an agreed periodic term and the rent is paid in advance before the lease starts. The periodic lease is renewed at the end of each term, creating a new lease which can continue forever. The tenant may have been there for several periodic terms, even surpassing 3 years, but it will still be recognized in law as a short-term legal lease. However, if the lease agreement has a term of over 3 years but is never executed by deed, it is recognized as an equitable lease, which will be recognized by equity. The requirement for an equitable lease is for it to be made in writing and signed by the parties pursuant to Section 2 of the Law of Property Miscellaneous Provisions Act 1989. Therefore, Mr. Rowland, I would advise you to go back and check your written agreement and check the length of the term of the lease for more clarity. Because you already have a written agreement which is signed by both parties, if the term of the lease exceeds 3 years, you will have an equitable lease. However, if the term of your lease is less than 3 years, your lease should be a legally protected legal lease. Due to the lack of sufficient facts, we can't really say with certainty which category your lease falls into. However, the lease will still be enforceable no matter which one it is. This is due to a principle from a case very similar to yours, which is Walsh and Lonsdale's. In this case, Walsh, the tenant, defaulted on his rent payment, so the landlord, Lonsdale, seized his goods as security for the rent arrears. Mr. Walsh brought this action to court and demanded for his goods to be returned to him and that the lease is not enforceable because it was not formalized. However, the courts ruled against Mr. Walsh and stated that an equitable lease can be enforced as if it's a legal lease. Therefore, even if the lease is not formalized, its terms can still be enforced. However, the requirements is this. The lease must be made in writing and signed by both parties, as explained just now, and the person seeking to enforce it must come with clean hands, which he must not have done anything unjust or has and/or breached the terms of the lease agreement. In summary, it is highly probable that no matter what your lease is, either being a legal lease or an equitable lease, Ricky is still bound by the agreement to pay the rent in advance. So now, since the lease is enforceable, we will continue to discuss what are the actions you can take against Ricky to have him either repay the rent or leave the property. Here are a few actions which you can take. However, from these few actions, you can only pick one or the other, and you cannot claim for all of them. If your main demand is for the rent arrears, then you can recover your rent through the Commercial Rent Arrears Recovery (CRAC) scheme contained within the Tribunals, Courts, and Enforcement Act 2007. Through this scheme, landlords of commercial premises, which your lease with Ricky for his motorcycle repair business falls into, may follow the procedure set in Schedule 12 of the Act and recover rent through a much more efficient and speedy process and prevent the delay which comes with taking the action through a court proceeding. Through this procedure, the landlord will need to appoint enforcement agents to seize goods from the tenant which the value cannot exceed the actual rent arrears as the recovery for your rent. Or you can also make a claim to court to take legal action against Ricky based on the grounds of breach of covenant to pay rent. However, a court process may be inefficient and cause undue delay to recovering the balance rent. However, you can also force Ricky to leave the land if there is a forfeiture clause in the lease agreement, which means that there is a clause that allows you to re-enter the land in case of any breach of covenants. Then that can be used to let Ricky leave the property, properly evicting him. To do this, you would need to have made an initial formal demand for rent arrears. If Ricky still does not comply, then you can either physically re-enter the property and take it back, or you can also apply to court order to enforce the forfeiture clause. Therefore, each of these actions will have their own pros and cons, especially anything going through a trial in court will likely take a much longer time and be less efficient. Whichever action you choose, however, will depend on your preference. Finally, Although it is highly likely for you to enforce the lease, but Ricky may also have his own defenses if this issue is ever brought to court. The most probable one that Ricky will raise is promissory estoppel. Promissory estoppel is a doctrine in law where a party, either expressly by words or impliedly by conduct, promises not to enforce their contractual obligation, and that this promise is relied on by the promisee, then the promisor is not allowed to enforce this right. In this case, because you accepted the 5 months rent in the beginning, which is contrary to the term for full payment in advance, he can argue that through this conduct you have waived your rights. There are 4 elements which need to be satisfied to prove promissory estoppel, listed in the slides, which includes that there needs to be a pre-existing legal relationship between the parties, and that it is clear that the promisor has waived his rights by promising not to enforce it, and that the promisee relied on it, and that it would now be unfair for the promisor to go back on this promise. However, promissory estoppel will cease when given reasonable notice. In your case, by informing Ricky to honor the agreement, you have successfully given reasonable notice. But Ricky himself continued staying without paying rent. So even in the event that Ricky raises this defense, we still have a high chance of winning. So in conclusion, the lease you have between you and Ricky is enforceable, although it does not satisfy the formalities requirement. You can recover rent arrears either through the CRAR scheme or by bringing this action to court, or you can evict Ricky by utilizing the forfeiture clause if there is one in your lease agreement. And even if Ricky raises the defense of promissory estoppel, it is highly likely for it to be disproved. This is the end of my presentation. Thank you for watching.